floor is now in session. All have cause to plead. Draw near. Give attention. We shall be heard. God save these United States, great state of Florida, and His honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning. Welcome to this session of the Florida Supreme Court. Justice Polson is unable to be here today for oral argument, but he will be participating in the disposition of these cases. Our first case today is number 21-1047, State versus Manigo. Whenever you're ready, counsel.
Thank you, Mr. Chief Justice, and may it please the Court. Christopher Baum for the State. Under Williams v. State, the Fifth District erred in failing to consider whether sentencing respondent under Section 775.082 1B1 without the required jury finding constituted harmless error. This Court should quash the decision below and remand for the Fifth District to consider that question in the first instance. And it should make clear that if the Fifth District concludes that the error is harmful, then the remedy for that error should be either to remand for resentencing under Section 1B2 or to impanel or to allow the State to impanel a jury to make the required jury finding. Now, turning to the first question, appellate courts review judgments, not the reasoning of trial courts. And whether or not the trial court made a harmless error finding in its opinion, the underlying error in the judgment is the same. It's the absence of a required jury finding under Elaine. And this Court made clear in Williams v. State that that appellate courts are required to consider whether that error was harmless error under the harmless error statute. Now, because this Court is a court of review, not of first view, the Court should remand for the Fifth District to consider in the first instance whether the error constituted harmless error. Turning to the remedy question, I think the Court should clarify that the remedy for a harmful error, a harmful Elaine error in this context, is either to remand for resentencing under 1B2 or to allow the State to impanel a jury to make the required finding. If we
agree with you as to the first issue, should we reach the second issue?
Your Honor, the second issue is important and recurring. As you know, it has come up several times, and this Court has been unable to address it. I think this case presents an opportunity for the Court to address it and to provide helpful guidance to the Fifth District on remand. If it does conclude that the error is harmful, it would help to clarify and to resolve the important conflict in the districts on that question.
Okay, can I ask you, maybe I missed it because I was trying to figure out if the clock was working or not.
Sure.
But what is your position, again, on trial courts performing or conducting harmless error analysis?
Well, I think this Court can provide clear guidance that if confronted with the same situation again, trial courts should either sentence the defendants under Section 1B2, which does not require the jury finding, or it should allow the State to impanel a jury to make the required jury finding.
I'm just having concern with the trial court in this particular case just conducting his own harmless error analysis and making a decision from that.
Yes, Your Honor. I think we're in agreement that the harmless error analysis is something that the district courts perform under the harmless error statute.
Right.
But under Williams v. State, the Fifth District was required to perform that analysis, and in fact, it had no power to reverse the trial court's sentence under the harmless error statute without concluding that the error was harmful. And so that's why we think the court should quash the decision below.
It's just having been a trial judge, I can see if we write an opinion saying, well, you trial court judges, you can go ahead and make a harmless error analysis, not just in this type of case, but other factual findings, other factual things. And I can see a situation where at the end of the trial, let's say the prosecutor gets up and says something, and let's pick something really outrageous that I would hope would never happen. But say something like, if a defendant is not guilty, why didn't he take the stand and testify and tell you that he's not guilty and tell you why? Obviously today that would be reversible error and probably a very strong opinion at least from me, and something like that. But I can see a situation where a trial judge would say, but you know what, this is closing argument, I already heard everything. We got videotape of a surveillance video of the defendant committing the crime. We have a confession from the defendant. We have DNA. He left his blood behind. We have fingerprints. We got people who identified him. So I'm going to make a harmless error analysis. I understand that that's wrong to do that, but a reasonable jury, rational, reasonable jury would convict this person and would not acquit just because that mistake was made by a prosecutor. See, I can see that kind of harmless error analysis all of a sudden being conducted. And that's the concern I have.
Sure, Your Honor. And I think in that instance, on appeal, a district court would certainly reverse in that instance. And so the harmless error analysis, whether or not the trial court performs that harmless error analysis, if the error below occurs, it's going to be subject to reversal if it constitutes harmful error in the district courts.
Well, I'm trying to avoid a case getting to us. We have enough to do.
Sure, Your Honor. But certainly the district courts could be able to clean that up.
So if I understand your position, you agree with Justice LaVarga that it was error for the trial court to conduct a harmless error analysis.
In this instance, I believe that you could call it error, but it is certainly not reversible error. And
well, I mean, but there's a lot of error that's not reversible error.
Absolutely, Your Honor. And
under Eileen, the trial court should have done one of the two things that you suggested, either impose a sentence under the new statute or impanel a jury, correct? That's your position.
That is, Your Honor. And it's also our position that the Fifth District erred in failing to consider whether the trial court's error.
So this would be like any other error under the statute, under the law. Our duty is to conduct a harmless error. The duty of the appellate court, the Fifth District, was to conduct a harmless error review to determine whether that error was harmless.
That's correct, Your Honor.
And they did that, or they didn't do that, so that's why we're here. And so I think Justice LaVarga's point is that maybe that just sort of seems unfair, that the error that the trial court had was to conduct a harmless error analysis, but then if the trial court was right, nothing happens. There's no relief for that error. And you admit that does sort of seem unfair, right?
Well, I think that on appeal, if the Court of Appeal thinks that there's no harmful error, then it doesn't have power to reverse that error. And whether or not the trial court provides analysis, the trial court could knowingly commit an error but not necessarily write that in the opinion, or it could conduct harmless error and say, well, I'm going to commit this error because I think it's harmless. Either way, the underlying error is the same, which is, in this case, you have a sentence that is unsupported by the required jury finding. And that is the error that the Fifth District was required to review for harmless error, and it failed to do so.
So far, sorry, go ahead. So far, we've been assuming that there is a harmless error analysis, that term means one analysis, but of course it doesn't. Can I hear the State's position on what the content of the harmless error analysis that should be applied by the court on remand, were we to remand with instruction to conduct it? Is it 924.33? Is it Williams? Are they different? What's the State's position on that?
I think it's Williams, and I think that it's whether a rational jury would conclude beyond a reasonable doubt that that Respondent actually killed, attempted to kill, or intended to kill the victim in this case.
Whether a rational jury, any rational jury, it seems to me the case presents, if it presents anything, an opportunity to refine what the content of the harmless error analysis is under Williams. And I'm wondering whether those two structures of it that I just outlined, a rational jury, any rational jury, are different from the state's perspective.
Well, I'm not sure that this case presents a great opportunity to resolve that particular question because, the parties have not briefed whether the standard is a rational jury, any rational jury, and I think that we're proceeding under this Court's analysis in Williams and the test that it set forth in that case. And the state's position is that the Fifth District should have applied the test set forth in Williams, whereas Respondent's position is that it was not required to do so. So I'm not sure that this case presents a great vehicle to address that question, Your Honor.
Are you familiar with the federal cases? I think at least in the Third Circuit that analytically sort of first ask whether it's in these Elaine cases, whether it's trial error or sentencing error, and when they decide that it's a sentencing error, they essentially don't look at the trial record, but they ask whether in the absence of the error, the same sentence would have been imposed. And so in this case, under that framework, if you deem this a sentencing error and you ask, without the court having, made this finding, could they have imposed the sentence? It seems like at least as to the review period, the 25 versus the 15, obviously that same sentence couldn't have been imposed. Is it possible that that's the right way to look at what the error was and how you apply harmless error that sort of gets at this issue of, I think it's weird to say that the circuit court didn't have the option of kind of looking at the record, that was kind of a wrong approach, but then for us to do a harmless error that looks at that as opposed to maybe looking at it analytically as just a sentencing error and then doing harmless error analysis on that.
I'm not familiar with those Third Circuit cases, Your Honor, but I think that the Williams approach makes sense in that you have a situation where you have an underlying Elaine error and there's the required jury finding is missing, and I think the analysis is much the same as in many other harmless error contexts where the court simply asks, well, okay, looking at what the jury could have done, would a rational jury have found beyond a reasonable doubt that this defendant was the shooter or intended to shoot or attempted to shoot the victim. I think if you simply analyze whether the trial court could have imposed the sentence without the required jury finding, I think the inquiry collapses. As Your Honor mentioned, you would look at this case and say, well, of course, without the required jury finding, you can't sentence the defendant under 1B1. It has to be under 1B2. So I think that, or to allow the state to impanel a jury to make the required jury finding. And that would be consistent with how this court has treated resentencing under Hearst and under subsection 10 of 775.082.
I mean, I guess the Hearst thing, though, there you at least have a statutory framework that assumes that there's going to be, in the death cases, that there's going to be a bifurcated, guilt phase and sentencing phase with fact finding. I mean, here we're kind of, it's no one's fault because you've got this confluence of, 3 separate lines of common law and then the new statute, and everybody's sort of trying to make the best of it. So on the front end, so going forward, is it fair to say that the right way to do this in a new case where it happens after the 2014 statute went into effect, that the jury that the question needs to be posed to the jury, and if that doesn't happen, could you reconvene a jury or have that same jury then in the sentencing phase do fact finding in that situation too?
I think that would present a slightly different question, and As you explained, there's the statutory framework in the Hearst context, but as this court explained in Game On, in the subsection 10 context, there was no statutory framework to necessarily address this issue, but the court has inherent authority to do so when the legislature has not yet had a chance to address the problem. And so, of course, going forward, if we're talking about a defendant who, well after the events and well past the procedural posture of this case, that the question was, well, they were inappropriate. The jury was not properly instructed, even though everyone agrees that they should have been instructed to make this finding. I think that's a much different question than what we have here, where we're simply trying to fix the problem that arose given the lines of cases that Your Honor is talking about.
Counsel?
Go ahead.
I want to just ask something you just said about our inherent authority to fix. How far does that go? Where is the line in which we can fix a statute that has constitutional issues? In Game On, the court at that point said, we feel like we can do that in this case. But there's definitely nothing in the legislative scheme that contemplated impaneling a jury years later. The legislature's always thinking about judicial resources. There's debate. There's policy considerations in a legislative scheme, none of which we are meant to address. So where is the line in our inherent authority that you speak of that would allow us to fix the statute or not? What is our kind of mark there?
Well, I don't think you would be crossing over the line in any event if you were simply to say that the remedy in this case is the same as it is in the subsection 10 context. We're talking about the same statute. We're talking about the same remedy of impaneling a jury to make the required jury finding. And that's consistent with how the court treats these errors in the Hearst context. Because even in the Hearst context, the bifurcated proceedings are not contemplated to fix this type of sentencing error. They're contemplated to ensure that the penalty phase and the guilt phase are distinct. And yet this court allows the use of impaneling a jury on remand for resentencing, because resentencing is de novo. And so I think it would be consistent with Game On. It would be consistent with Hearst. It would be consistent, and it would treat Elaine errors across the board consistently, where you have the absence of this finding. That trial court should have the option to impanel a jury if the state so chooses.
And in this particular case where the state never even hinted at asking the court to have a jury come in, I mean, should that affect, I understand people would, systemically it might be good to have some certainty as to what the court thinks as to what are the available remedies. It seems odd in this particular case to have that be the remedy.
Well, Your Honor, I don't think that there's any question of preservation, because it would have been futile for the state to have requested either in the trial court or in the district court to allow the state to impanel a jury, because under Williams and Williams's remedy holding, that wouldn't have been an option. And the state is not required to preserve a futile or make futile attempts to preserve remedy requests. So I don't think it would be.
Your position here, what you're asking us to do is to remand the case back and impanel a jury and make this decision.
No, Your Honor. Just to clarify, the state is requesting that the court quash the Fifth District's decision below and remand for the Fifth District to consider whether the error in this case was harmless in the first instance. Now, if the Fifth District concludes on remand that the error was harmful, then we're asking that the court clarify that in that circumstance, the Fifth District can remand to the trial court either to resentence Respondent under 1B2 or to allow the state to choose whether to impanel a jury to make the required jury finding.
Counsel, you're into your rebuttal time.
Thank you, Your Honor.
Good morning, Your Honors. Matthew McLean on behalf of the defendant, Herbert Leon Manago, who's the appellee in this case. I'd like to begin by addressing the error that was committed in this case by the trial court. At the time of the resentencing, the trial court was armed with the decision of Williams. It recognized Williams required a jury finding as to whether the defendant actually killed, intended to kill, or attempted to kill the victim in the case. Knowing that, it proceeded to go ahead and commit an error because it deemed the error would be harmless. A court is supposed to faithfully apply the law, not commit error knowingly and because it believes the error to be harmless.
The verdict form that was provided to the jury did not provide, did it, for the jury to make a determination that the defendant was the shooter?
It did not. It had no special jury findings. So the jury verdict form was for felony, first-degree murder, and carjacking with a firearm, but no special verdict findings were requested.
Why is that? I mean, I don't understand why that wasn't provided to the jury.
I believe it was the state's position that they didn't need to prove it to get the conviction. To get felony first-degree murder, they said, look, we believe that he was the shooter in the case, but we don't have to prove it. He could be a principal in the situation. So because we don't have to prove it, don't decide it, just find him guilty of felony murder and armed carjacking with a firearm.
So under that theory, any of the three could have been charged with being the shooter?
Correct. And if you look at the
sentence as the shooter, I mean.
If you look at the indictment in the case, the state charges him as if he was the killer in the case, but then it alternatively charges him as if he was participating and helping the co-defendants who might have been responsible for the actual killing in the case. So the state proceeded under dual theories below. So the state's taken the position that the harmless error analysis was not conducted by the Fifth District Court of Appeal. The Fifth District went ahead and clarified its position, saying it did conduct a harmless error analysis. While it's not the one in Williams, it's an analysis of, I think, more of a practical approach. What would have happened correctly under the situation? If the court would have found that there's no jury verdicts to support the enhanced sentencing, they would have sentenced Mr. Manago pursuant to 1B2.
Are you asking us to overrule Williams?
No, I'm not asking you to overrule Williams.
So then what's the justification for the departure from Williams?
I believe it's the error that's committed. I believe that cases decided prior to Williams did not know that they were knowingly committing error. It's only after Williams came out which a court then becomes aware of the law. And if they recognize the law and go ahead and commit an error knowingly just because they conduct their own harmless error analysis, that's the problem that is trying to be avoided. So there's no reason to overrule Williams. The practical approach going forward is courts, and there's no verdict to support an increased sentence, then they should go ahead and impose a sentence that complies with the verdict form.
I mean, subsection 2.
Correct, under subsection 2, and that's practically what should have happened in this situation post-Williams.
In terms of appellate standards, what you're arguing for is a per se reversal rule under these circumstances. Is that correct?
Under this situation, it would.
For Eileen error that's committed because a trial judge performs the harmless error analysis that they're not supposed to perform, you would say it's a per se reversal rule is appropriate in those instances.
Correct. If recognizing that it is the law, then it would be per se not to follow the law. Essentially, you would be encouraging courts to go ahead and commit an error with the hope that later on the appellate court's going to go ahead and find the error to be harmless, and that's something that should be discouraged, not encouraged.
How do you square that with the statutory directive that appellate courts not reverse except for harmful error? And within the context of we know what harmful error is, that's error that would have made a difference. And I heard your earlier argument, but please address that.
So I guess I would stick with my position before, is that the harm isn't what the result would have been. It would have been a different sentence under 1B2 compared to 1B1. And that's where the error is harmful in this situation. But even if this court were to apply the Williams rule harmless error analysis, there's no reason why this court couldn't decide whether the error was harmful. In Williams, in announcing the rule, this court actually conducted a harmless error analysis and found that the error was harmful. So there's no reason to have the court go back to the District Court of Appeal when this court is able and has done so in the past in conducting its own harmless error analysis. Believe that the error is harmful in this case. It falls in line with the cases where there's multiple defendants who were charged with the crime. There's multiple theories presented as to who the killer was, and there's no clear verdict finding as to what the jury actually decided.
Doesn't the statute sort of whoever wrote this statute thought that there was going to be a judicial finding on affirmatively whether the person, met any of these criteria. I mean, if you read the statute literally, it's not really, in the absence of a finding that they were the shooter, it doesn't really allow you to apply to, because it says a person who didn't actually kill, intend to kill, or attempt to kill. In this case, we don't have any jury finding that he wasn't the shooter. So should that factor into, should we, given sort of what the requirements of the statute actually are, doesn't that kind of lead us to, to say that the only right thing to do here is, in every one of these cases where we're trying to retroactively apply the statute, that we do need to have a jury come in and kind of decide one way or the other which box they fit into, which box the defendant fits into?
So are you talking about the remedy, assuming that there would be
Well, I'm talking about how to comply with, because there's kind of an assumption that you quote unquote, comply with the statute by assuming that the person wasn't the shooter just because of the absence of a finding. But the statute isn't really, it's not written that way. The logic of the statute is that at the time of sentencing, you're going to know which box to put the person in. And the absence of a finding doesn't allow you to put them in the B2 box. It just means that you can't necessarily put them in the B1 box.
I agree. I think the statute is written so when you come to sentencing, you're going to know whether the defendant falls under B1 or B2. And that's unlike subsection 10 in the statute, which is more of a sentencing consideration. It says that, and I think that's the reason why in Gaiman this court crafted the remedy it did, is because the legislature intended post-verdict for a judge to decide whether a non-state prison would be dangerous to the public. In the situation of 1B1, it's contemplated and going forward in the standard jury instructions that the jury is going to be instructed as a matter of first impression in reaching the verdict of whether this person actually killed, intended to kill, or attempted to kill the victim. And the same goes with the death penalty context. It's contemplated by statute that there's going to be a guilt phase and a penalty phase, and these penalty phase sentencing factors are going to go ahead and be considered post-guilt verdicts. So coming back to, what ultimately the remedy is going to be in this case, we understand it's a unique set of circumstances that, this is a law that's being applied retroactively, and the parties were not in a position of knowing that at the time. But that doesn't go ahead and throw out all the other law that's in place as to what should happen in the case.
And you don't have any case standing for the idea that a reviewing court applies harmless error differently depending on whether the judge, depending on the clarity of the law that the judge was departing from below. Because the logic of your position is that after Williams, if a court, in Williams, the trial court had done the fact finding, I guess, in some kind of, new hearing. And yet we said that there needed to be harmless error analysis there. The logic of your position seems to be that if a judge today held a hearing that that the reviewing court then couldn't do harmless error review because it would have been such a clear error that it was intentional. Isn't that what you're saying?
Yes.
And there's no, you don't have any case law support for harmless error being applied differently depending on whether the judge knew what the judge was doing was error.
Not in this exact context, but I think if that were to be the approach taken, then a lien apprendi errors would have no real meaning to it, because the appellate court would just simply, or the trial court would simply say, I'm going to impose the increased sentence because I'm able to, even though I know I'm committing error, because ultimately it's going to be harmless. So if you don't find that to be error, then it's going to be encouraging courts to not follow the law faithfully. And so it's a unique set of circumstances, and I think that going forward, everyone would agree that
but you could make the same point about a harmless error analysis in any case. That the fact that that is there is an incentive for errors to occur if a judge thinks it really doesn't make any difference, and it's not going to make any difference at the end of the day. I mean, it seems like I don't understand the limiting principle that that you really can rely on. I mean, I understand. I mean, I agree with you. The judge should not have done this. The trial judge should not have done this. But I'm struggling to find some kind of limiting principle that would not really basically undermine the whole harmless error enterprise. Now, I know some people think we shouldn't have harmless error analysis, but we do. And so what am I missing there?
I think the key part that's missing is the knowing part, knowingly committing error in the situation. In this case, we're fortunate enough to know that the court recognized in his order that he was committing error, but conducting a harmless error analysis. So if you have a...
Well, but there are some errors that trial courts make that are pretty clear. Is it every time that there's law that shows that, I mean, we presume judges know the law. Every time a judge makes an error where the law is clearly established, that we would presume the judge is on notice of the law, that we presume that that's intentional.
I guess I'll put it in an example. Say there's a hearsay objection, and it's clear that it's hearsay, and the court says, you know what, I'm going to go ahead and allow that hearsay to be admitted because I know in the end of the day it doesn't really matter. It's going to be harmless. You know, in that situation, you're having courts make decisions.
So is it
off.
more like your theory is more like loose lips sink ships? The judge might think that and act accordingly, but if he articulates that, then we're in a different territory.
I think if he articulates an harmless error analysis on the record, then the judge should be reversed in that situation. Going to the remedy in this case that the state's asking for to impanel a jury, I'd like to first start off with preservation. Trial court silent as to requesting to impanel a jury. Briefing at the Fifth District Court of Appeal, silent as to requesting the ability to impanel a jury.
But so this was going on after Williams, right?
Correct.
Well, wouldn't all that been futile?
I don't think it would have been futile. You would have preserved your argument. If you want to overturn something, you present the argument knowing, and you cite to the case law, we understand that Williams is the law. However, we think it's wrongly decided for these reasons, and you present and preserve the argument. So
do we require that?
I think that you have to fairly present the argument to the court
to
below.
A court that can't act on it? Do we require that? Do we have cases that require that?
I think certainly maybe not at the trial court level, but the appellate court level, and where the state goes even further in this situation, at oral argument, when they're confronted with, well, what is the remedy that you're asking for? Do you want to have a jury impaneled in light of the Green decision? Since now
do
there's
you have
conflict.
a case where we have required that in circumstances like this, where we have a binding precedent, a precedent that binds the trial court and the district court, where we require that an argument be made for the overturning of that precedent in the trial court and the district court?
On hand, I do not, Your Honor.
Pardon?
On hand, I do not have a case that says that. But I would like to point out that when confronted by the Fifth District Court of Appeal, they said, look, I don't even know. I doubt that we would impanel a jury 15 years later after the fact. So when given the opportunity to post-Green, when there's now a conflict between Williams and Green, to seek that remedy, that the state said, you know, we don't even think it would be something that we would do.
Assuming we don't agree with your preservation argument, what else you got on this?
Stare decisis. This court went ahead and decided Williams 4 years ago. It confronted the exact issue that is being presented here as far as a remedy to impanel a jury. And they're asking this court to overrule the precedent when really there's been no reason to go ahead and do so. The decision has proven workable. It would lead to an injustice of Mr. Manago being treated differently than other defendants like situated. And there's been no factual circumstances that would justify departure from this court's precedent.
So your position here today then is that it wasn't proven during the trial the jury didn't make the finding, that is. And therefore, we should remand it and instruct the trial court to sentence Mr. Manago pursuant to subsection 2.
Correct, just as it did in Williams.
That's what we did in Williams.
Correct. There's no reason to do so. And in the briefing, the state hasn't provided a single case that approves the practice it's requesting under these circumstances. The only case law that's out there at this time is saying you shouldn't do it. This court did it in Williams. This court cites a Pena from the First Circuit Court of Appeal. I provided this court with case law from the Pennsylvania Supreme Court, which, like this state, has capital sentencing proceedings and bifurcated sentencing proceedings. And the Pennsylvania Supreme Court, in the same situation, said, look, we're not going to legislate from the bench. If the legislature wants to come up with a mechanism to impanel a jury post verdict, let them go ahead and do that, but we're not going to touch it. So every jurisdiction that I'm aware of, when presented with similar situation, has not gone the direction the state wants its court to go. And when you even look at the United States Supreme Court in Alene, their remand instructions was send it back for resentencing consistent with the verdicts in the case. That's what we're asking for this court to do.
I'm going to read from Statement v. DeGaio. Per se reversible errors are limited to those errors which are so basic to a fair trial that their infraction can never be treated as harmless. And then from Trapman versus California U.S. Supreme Court, when involving constitutional violations, such errors are always harmful. Now, and the idea is, like, if a defendant is completely deprived of counsel at trial, that's a constitutional violation, it's a structural violation. And so as I understand your argument, because this is a constitutional violation, the right to have an issue decided by a jury, it's structural, and it's the kind of error that needs to be treated as per se reversible in order to get the relief that the Constitution warrants. That's your argument?
I believe that's a good way of summing it up.
And then how does that square with Williams? If we accepted your argument, how could we maintain the Williams harmless error directive for appellate courts to do in these circumstances?
So we're going back to whether error was committed in the case?
No, I mean, Williams says that the appellate courts to conduct a harmless error analysis in this circumstance where
I think the error occurred, one step before reaching Williams. It's a different type of error as recognized by the Fifth District. So it's not a Williams error per se. It happened before it got there. So that's the best argument I have for that. But even going back to if the court says, look, you still have to conduct a harmless error analysis in this case, there's no reason to find that the error would be harmless in this situation. And I would add to not only the circumstances of the trial in this case, but talk about due process consideration. If there's going to be such an important finding that's going to change someone's sentence between a mandatory 40-year sentence and a 15 versus 25-year review, shouldn't that defendant be put on notice of that requirement and be able to present evidence, an argument to a jury to make that finding? To go ahead and just say things would have been the same and let's conduct a harmless error analysis based off what was put forward to that trial when now the rules of the game have changed, that would be a due process violation in our perspective. See that I'm running out of time. So in sum, I'd like to ask this court to affirm the remedy provided for in Williams. I'd like for the court to affirm the Fifth District Court's finding of error in the case and to remand for Mr. Manago to be resentenced pursuant to 1B2. Thank you.
Counsel, can I ask you a question? So it seems, the fact that the state here didn't ask for a jury to be brought in and, lots of time has gone by, it seems like in a lot of cases there are going to be serious practical problems, even if it's a legally available option. And it seems like under a lien, it's not a constitutional option for the judge, him or herself, to have a fact-finding hearing where the judge makes the determination. Is it the state's position that it's not, if we're thinking about, what should the rules be going forward in these cases where we're applying the statute retroactively, is it the state's position that it's not a constitutional option to essentially tell trial courts that they can, they're bound by whatever happened at trial, there's no kind of new fact-finding, but that they can sort of look at that record and decide whether any rational jury presented with this information would have found beyond a reasonable doubt that the person was the killer or met whatever the B1 criteria are? Is that off the table?
I think that option's off the table because I think it's the same as the judge making the finding.
It's not. I mean, it's not really the same thing. I mean, it's you're not. It's not the judge kind of affirmatively finding as a fact. I mean, it's you're limited to what happened before, and it kind of gets back to this question of if we sort of reinvent things, was the error the failure to not have it, during the trial? We all know that the reason why it wasn't done is because the law changed.
Sure.
But if you sort of reconstruct the error as the failure to have had it there, then, there is a real difference between sort of confining yourself to that. The state doesn't get to do anything new. The judge isn't sort of exercising their own kind of sense of, of what the fact is. They're just looking at that. But your position is that that's not constitutionally an option.
I think that's right because on appeal, again, the District Court of Appeal is reviewing the judgment, not the reasoning of the trial court. And so, whether the trial court said I can sentence under 1B1 because I'm making the finding, or whether I can sentence under 1B1 because I think doing so would be harmless error, either way, the error underlying the judgment is the same. And so the question for the District Court is whether that error was nevertheless harmless under Williams. And just a couple of other quick points. The reason why the jury form did not require the finding here was because this occurred pre-Elaine, and so there was no reason for the trial court to have included that in the jury form. I think Your Honor formulated
You're saying it wasn't a purposeful choice by the state to proceed in the alternative in the way your opponent suggests.
Well, it was a choice to proceed both on the principal theory and on the first degree theory, yes. But as for the jury finding, that was pre-Elaine.
Well, it wasn't just pre-Elaine, it was pre-2014. I mean,
Yes.
it's the statute that made this.
Yes, that's right, Your Honor. That's right. And I think Your Honor formulated the per se reversible harmless error theory perfectly in that it's loose lips sink ships. If the trial court is considering, an objection to the introduction of testimony that's, nobody is really going to care about this after the trial, and the trial court thinks, well, I think it would probably be upheld as harmless error on a review, so I'm overruling the objection. Nobody would think that objection would not be subject to harmless error on appeal. But then if the trial court goes ahead and says, I think this will be harmless error, and overrules the objection, that is somehow per se reversible, I don't think that there's anything in this court's case law that supports that theory.
Counsel, I have a question about the preservation issue quickly. You argued here in your brief that Gaimon essentially sort of undercut everything Williams stood for as far as the empaneling a jury. I think, is that a fair reading of what you're arguing?
Yes, Your Honor.
Did you argue that at the Fifth?
No, Your Honor, but the case law that provides that we do not have to make such futile arguments is cited in our reply brief.
It's not really a futile argument if you're arguing that there is no precedent then. I mean, you're arguing they've already changed their minds at the Supreme Court Fifth, and you can follow Gaimon now.
Well, I think to be clear, to clarify my previous answer, I think that the district courts could not have extended Gaimon into the Williams context because Williams still remains good law until this court recedes from it. And I see that my time is up unless the court has any further questions.
You want us to include loose lips sink ship in our opinions?
If at all possible, Your Honor. Thank you.
Thank you.
The lights are not working.
We're going to take a 5-minute break to try to get our system fixed here. So the court will be in recess for 5 minutes. Thanks.
All right. Supreme Court of Florida, session. Please be seated.
We apologize for that. Our next case is number 21-1479, Trapman versus State of Florida.
Thank you, Mr. Chief Justice. May it please the court and counsel. My name is Michael McNamara. I'm the General Counsel of the Public Defender's Office for the Second Judicial Circuit, and I have the privilege of representing David Trapman, the petitioner here. What the petitioner is requesting the court do on this case is to send the case back to the Santa Rosa County Trial Court with instructions to vacate count 2 for double jeopardy grounds and resentence as to count 1. I don't think resentencing is appropriate as to count 3 since that was a first-degree misdemeanor. The court would certainly have imposed the same sentence on that one. The reason is that the First District Court of Appeal erred when it found...
Now, what were the sentences here?
10 years on count 1, 5 years on count 2, 1 year on count 3, everything concurrent.
Everything concurrent.
Everything concurrent, yes, sir.
So count 1 was what?
Aggravated battery on a law enforcement officer. Count 2 was battery on a law enforcement officer.
So count 2 was a third-degree felony?
Yes, sir.
And count 1 was second-degree felony?
I believe count 1 was a first-degree felony.
First-degree felony.
Yes, so maximum punishment, I think his maximum exposure would have been 36 years in the Department of Corrections, and he received 10. The reason that the petitioner believes it should be sent back to the trial court and the First District Court of Appeals opinion should be overruled is because the dual convictions do violate double jeopardy. The reason for that is that the charging document does not allege specifically in count 2 that the battery on the law enforcement officer was a shove. That may have been the state's theory, that may have been what they believe that the evidence showed, but this court has been very clear that when you are doing a double jeopardy analysis, before you reach the distinct acts analysis, you look and you see whether or not the charging document, which is on page 17 of the record, alleges distinct acts. And count 2, the language in count 2 is simply the lesser included language of count 1. The count 1 does allege a deadly weapon. I believe the only actual difference between count 2 and count 1 is in count 1, I believe it says that the actual and intentional touch or strike was against the will of Officer Byrd, and in count 2 it said the actual and intentional touch or strike was without Officer Byrd's consent.
Same double jeopardy analysis if the shove and the dog sicking had been separately alleged, or does it make a practical difference from the standpoint of determining whether or not your client was twice in jeopardy of loss of liberty?
Ultimately, I believe that we'd be able to show that double jeopardy still does bar the conviction had it been properly pled. So under the example you're giving, count 1 does allege the bulldog is the deadly weapon. Had count 2 alleged that the intentional and actual touch or strike had been a shove, then we would move to the distinct acts analysis. And I think that the four factors that are expressed in Parch, which is cited in the briefs, goes through number 1, which is whether there is a temporal break. I don't think the parties disagree that there was not a temporal break. This was, according to Officer Byrd's testimony, he tried to shove Mr. Trapman out of the house. Mr. Trapman responded by shoving him back. Officer Byrd then re-engaged him, started pushing him out of the house, and that's when Mr. Trapman said, "Dog up."
Help me understand, though, how the intention is the same. Obviously, if we take a step back, there is a desire to repel the officer. But I think it's fair to say that the case law is slightly more granular than that, and it would seem to me, and I'm asking you to respond to this, that the intention of the shove is to, push him back, dislocate, whereas the intention of sicking a dog on someone is clearly to inflict grievous bodily harm. It would seem to me like that would be a shift akin to changing weapons in the middle of a battery, which might cause there to be two separate offenses. How do you respond to that?
And then that's number 4, and we can just jump straight to number 4 as far as the considerations. It's not, the language is not that it's the same intent. It is whether a new intent is formed between the acts. So we are limited to looking between the shove and dog up. And in between those two things, is there a change in the intent? And based on the testimony of Officer Byrd, there was no change of intent, because Officer Byrd testified that when they got to the house, they started They entered, and the two dogs
Why is Officer Bird's testimony as to the intent a relevant consideration? He's perceiving the actions that are, isn't the relevant intention the intent of the defendant?
Yes, and Officer Bird's testimony as it relates to what the defendant was doing, because Officer Bird's observations of the defendant show the defendant's intent. So when the officers arrive at the house, the dogs are milling around. They're walking around the officers. They're not posing any threat at all. Mr. Trapman is combative. He is confrontational with the officers. He's instructed to go outside. He goes outside, and Officer Bird testified that he has the two dogs out there. He's bashing their heads together. He's riling them up. He's getting them ready to go. I believe when they, according to Officer Bird and maybe one of the other officers, when they entered the house, Mr. Trapman made some comment to the officers about, I hope my dogs don't bite you. So,
well, but that all might be indicative of a desire to intimidate and to create fear. But let's put aside this notion of intent for a moment, and let's talk about impulses. Why wouldn't we think of the scenario here be a scenario in which there is a separate impulse which actuates this command to the dog, up dog, which results in the, it appears, results in the biting of the victim, and that is really what our focus should be on.
Well, the focus needs to be on the intent, because the distinct acts analysis is about a change in intent, not a new or separate impulse.
Well, there's some law that talks about impulse, separate impulse.
And
I mean, going all the way back to Blockberger.
Well,
now I think sometimes there's confusion, and let's just stipulate that our law on this is not, in this area, is not a model of clarity. And sometimes I think there might be a conflation of the notions of impulse and intent. But there is a difference between intention and a volition. Wouldn't you agree?
There can be, yes. I understand your point, Your Honor. Here, though, I think that the issue is very clear, because the charging document does not allege the shove. The charging document, count 2, is just the lesser included of count 1. The jury instructions, the lesser of count 1, is the exact same language, line for line, sentence for sentence, word for word, verbatim, as count 2. So without the charging document properly alleging it, then you don't even get to the distinct acts analysis. Now, I understand engaging on the distinct acts analysis, but the point about the dog and the impulse to use the dog was present. I would say that is shown by the fact that Mr. Trapman did not leave the dogs out in the yard. The dogs came with him, and the dogs were there in his house. It would be different, I think, if you were to consider the dogs being a gun instead. If he's bringing the gun with him, if he is actively loading the gun and chambering rounds while the officers are in the house, if one of the first things he says to the officers is, I hope you don't get shot while you're in here, you can say that that's trying to put them in fear, but an assault is just a battery that hasn't happened yet. And when it comes to the language, which is intent, I think that he does have that intent the entire time. When you read the record, when you read the testimony of the officers, it's just, you know, the anxiety is palpable. You know these dogs are going to get used. It's just a question of when, based on them milling about, and particularly Mr. Trapman agitating the dogs out in the yard before he goes back in the house to re-engage with the officers.
Just to clarify what happened here, maybe I'm a little confused with the facts. My understanding is that he was told he couldn't come in. When he tried to come in, the officer told him he couldn't come in, and then he shoved the officer with one hand. And then at that time, the officer shoved back. Did Mr. Trapman, at that point in time, have the pit bull by the collar with the other hand?
I don't remember. I mean, that's on the record if that's where it is. If he has
I thought he had the dog in one hand, the pit bull in one hand, holding him by the collar, and that's when the officer, shoved the officer shoved him back. He fell kind of back, and he told the dog, do whatever.
And Justice, as I stand here right now, I don't remember that nuance in the testimony. Okay. I think that if Let's say he did have the dog by the scruff of the neck, I think is what the testimony was, the scruff of the neck or the collar. I think that would show even more that he has the intent to use the dog since he brought the dog with him. But dogs are such that you don't need to have physical contact with them in order to order them to do something. You can order a dog to do something from a great distance away, and the dog will act.
Okay. Well, I mean, because what I'm saying is, if that's the case, it seems to be one episode of the shoving back, go dog, as opposed to being shoved back and going to get the dog and coming back, and that would indicate 2 episodes.
I would say that in the second part of the example you gave, where he leaves to go retrieve the dog and come back, I think that would still be the same episode, but I think that you would be talking about whether or not distinct acts that the legislature intended to punish differently occurred during that episode. So I think here, because when you run through the analysis for the distinct acts, which again the petitioner says we don't even arrive at since the charging document is insufficient.
Counsel, on this business about the charging document, could you point me to exactly where in your brief you've argued the point about the charging document?
Where in the brief it has been argued that the charging document? I believe we cited in the brief, we cited to Lee, which this court is an opinion from.
I beg your pardon?
We cited to Lee, this court's opinion from 2018, where it reversed the First District Court of Appeal, which jumped straight to from the information. It skipped over the charging document and right into analyzing the evidence.
Is that in your initial brief?
I don't recall if it's in the initial brief or the reply.
Well, you know, you need to argue things here that are argued in your initial brief, as I'm sure you know.
Yes, sir.
So if you could maybe figure out exactly where that is in your initial brief, it'd be helpful.
Yes, sir.
I'm not saying it's not. I mean.
Yes, sir. I'll take a look at that during my downtime and address it on rebuttal.
Doesn't the text of the battery statute essentially make it a matter of prosecutorial discretion whether to charge, each separate kind of unwanted touching as its own distinct act versus kind of treating it all as a course of conduct? If you just focus on the words of the statute.
It's going to be very fact dependent, but yes, I think there is a broad amount of prosecutorial discretion to charge separate acts in the information. But again, here, the separate acts were not alleged in the information.
Backing up, a quote from Whalen versus United States. Under the question under the double jeopardy clause, whether punishments are multiple is essentially one of legislative intent. So that's where we start. And I'm wondering, as I understand your argument, 775.0214 gives us the answer in this case. Is that correct?
Yes, specifically in 4B, 2 and 3.
And I want to go up to A and look at 4A. It reads, whoever in the course of one criminal transaction or episode commits an act or acts which constitute one or more separate criminal offenses. And here, as I understand your argument, the criminal transaction related to the aggravated battery charge arguably started in the yard when the defendant was exciting the dogs. Is that correct?
Or even earlier than that, when he makes the comment about, I hope my dogs don't bite you.
And then when would that transaction or episode have ended?
When he was tackled in the yard and taken into custody after resisting without violence.
Okay. And you argued in your initial brief that that was one transaction or episode, and I don't believe that the state contradicted that. They agreed with your statement of facts. Is that correct?
I believe the language was that they did agree with the statement of facts, and they had other ones that they wanted to emphasize, but they would do that in their brief, is the position I believe they took in their answer brief.
So your argument is that we have one criminal transaction or episode that constitutes the aggravated battery that temporarily starts in the yard or earlier and then ends when, as you indicated, and then, so whoever in the course of that criminal episode commits an act or acts which constitute one or more separate criminal offenses. So you would argue that the battery that was committed during that temporal period was a separate criminal offense.
The state is arguing that. I'm arguing that it's not. The state could have tried to charge it that way by saying in count 2 the actual and intentional touch or strike was the shove, but since they did not do that in the information, then we don't reach the distinct acts analysis. It's resolved just on the charging document, and count 2 is a lesser of count 1.
Okay. But under the statute, Okay, I understand your argument. When you get down to B, when it talks about the specific legislative intent, doesn't it indicate that even if it is considered a separate act under A, because it's an act that's committed as part of one transaction or during the course of one transaction or episode, that it is still subsumed and only one punishment is given because of the defenses or degree variance of one another, or alternatively, it's a lesser included?
Yes, either that or alternatively.
Okay.
And
Well, let me ask you about B and what B is really about. Now, if we had a circumstance here where there's no shoving, there's no pushing, there's by your client, maybe he gets shoved, and then his response to that is up dog, up dog. That's it. Now, we know that let's just say this, a jury could conclude that the acts involved there constitute a battery, and then based on other things, they could conclude that the act involved there constituted aggravated battery. Isn't that the kind of scenario that B, 4B is designed to deal with, so that your client would not be exposed to the punishment for the battery, which you can't commit the aggravated battery without committing a battery, and your client would not be exposed to the punishment for a battery and the aggravated battery based on that one act? Isn't that what 4B is about?
4B, you have to come back and you have to look at what was charged and what was convicted of.
Well, let's put aside that, because I've looked in your brief. I can't find in your table of cases a reference to Lee. Again, it might be there. That might be a mistake, and unfortunately I don't have my iPad where I could search. But let's put that aside so you can come back and show me where that is. But putting that aside, isn't that what we get to this distinct acts issue? Isn't that what B is about? It's about not doubling up where there's a particular act that constitutes an aggravated level of a crime, but also constitutes the subsumed crime.
And that is a legal question that the court would have to determine afterwards. I think that under the scenario you gave where there was no shove, it's just dog up in response to being pushed out of the door by the officer. The state, I believe the state would have, in their discretion, it would be permissible for them to file the exact information that they filed in this case and allege a lesser included offense as count 2, and then whether or not those two convictions could both stand would be a legal issue for the court to decide afterwards. If the jury felt that count 1 had all of the elements met, then they would necessarily need to find him guilty of count 2 as well, because count 2 is simply a lesser included of count 1.
Counsel, you've used up 3 minutes of your rebuttal time.
Yes, thank you, Chief Justice. I'll reserve the rest.
Good morning. Thank you, Your Honors. My name is David Welch, and I represent the state of Florida in this case. In the state's position, and I believe this court has stated previously in their cases, that the double jeopardy analysis is a 3-step analysis. The first step is, did the offenses occur during the same criminal episode? Different episodes, clearly not double jeopardy. You don't move on. But if it was the same episode, and the state did concede in this case that this transaction was one criminal episode, you have to ask if the offenses were distinct criminal acts. And as the statute states, the intent of the legislator is to convict for each criminal offense during each criminal episode. And you can go back to Blockberger itself, as this court did, I believe, in Graham, and Blockberger looked at the two issues, whether a defendant could be charged more than once under the same statute for multiple acts within the same criminal episode, and 2, whether a defendant could be charged under more than one statute for a single act that occurred within one criminal episode.
Can you just run by your understanding of the facts, how this happened?
My understanding is the officers, the three of them arrived at various points to serve a felony warrant on the appellant's wife. He was, I think, demanding to see the warrant. I believe the first officer who responded didn't have it, so that kind of started the confrontation between them. At one point, he goes outside, and that's when the officers say he seems to be riling up the dogs. As I think at some point then, he attempts to come back inside, and that's when Sergeant Byrd initially tries, and I think in his words were, guide him back outside with one arm. The defendant responded to this one-arm guiding by pushing Sergeant Byrd at least hard enough, he said, to knock him back several feet. At this point, Sergeant Byrd responded by, I think he grabbed the appellant with two hands to drive him out, forcibly take him outside, and that's at the time when the appellant said, "Up dog, up dog."
So where was the dog at that time? Did he have him by the collar?
I don't recall if he was holding him by the collar or if the dog was just the dog was in one of the dogs. It sounds like one of the dogs was in the room. I'm not 100% sure if the appellant was holding him or not. And then the other dog was somewhere else in the house.
So the entire incident occurred when he came back the second time?
Yeah, yes.
That's when the shoving
the two acts, yes.
And the dog occurred.
Yes.
Go ahead, finish your answer. I didn't mean to.
Oh no, and so I was going to go back. So if they're two distinct criminal acts, we don't go to Blockberger, the elements test, because and I think one of your honors was talking about the elements test would be if it's a single criminal act.
Right.
And so an example of one criminal act I believe this court's used in the past is if I carjack someone while holding a knife. It's one act of I'm holding a knife at someone while I steal their car. Now we look at the elements test, and then I have the holding the knife, the threatening, that's an aggravated assault that requires me to point the knife, whereas carjacking requires me to steal a car. So those have different elements. That's one act, but we allow two punishments for it.
So I guess one way to state the question, which we'll call unit of prosecution, is are you suggesting that when we're trying to decide whether two things are separate units of prosecution, that the test is Blockberger, whether they have different elements, or is there a more nuanced way of determining whether the unit of prosecution is different?
Yeah, it's a more new, and that's where my original point of it's a three-step analysis. So first you look at the episode. If it's different episodes, obviously different charges. Then is it a separate?
So just so we're clear, so obviously the state's position would be that had this defendant done either of the two things, the shove or the up dog, either one of those would be separately chargeable from the standpoint of a unit of prosecution.
Yes, Your Honor, and I believe and borrowing this court's language from Droughty, is it a separate and distinct act by itself? So as the state, if I prove that he shoved the officer, that has nothing to do with my proof that he ordered the dog to attack the officer.
Okay, so then I guess the next question becomes, so there is some universe of different units of prosecution, the simultaneous pursuit of which does not constitute double jeopardy.
Right. Okay.
Help me articulate what the rule is for sorting the wheat from the chaff on those.
Well, unfortunately, I don't think there's a bright line rule. It's going to be very fact specific to the case. You know, you might define act as like a separate impulse of a distinct character, but then you need to look at each individual case, you know, and I think each one's going to be different because, you know, what's the impulse? Is it one victim or are there multiple victims? What's the character and the type of the act? Is there a temporal break? Is the act a necessary and integral part of the other act? Do the locations change and potentially how it is charging the information? But none of these are definitive. For example, usually if we have two victims, we say, well, that's two different acts.
So what do you think makes it definitive here? Because obviously you're arguing that it is definitive here. What's the change that makes these two things simultaneously chargeable and prosecutable as separate units of prosecution?
Well, I think in here, different impulses, different character, the nature and the type and character of the acts are different. Me shoving someone is different than me ordering a larger dog to attack someone and bite them. And I believe he still had scars over a year later from the attack. So it was obviously somewhat serious. And again,
that's the aggravated battery.
Yes, Your Honor. And again, it goes back to, if I prove the shove, I haven't proved the dog attack, and if I prove the dog attack, I haven't proved the shove. They require different elements of proof from the testimony here. And then the temporal break, it's something you look at, but it's not necessarily definitive, because if you look at a case like Drowdy with a sexual assault where it was simultaneous, where you had the lewd and lascivious touch and the penetration occurred simultaneously. But then on the other hand, you could have a theft type case where that's going to take place over a period of time, but it's the same, if it's one victim, you're stealing all their stuff, you know, it's the same impulse to steal. So there, again, you have to look at it individually. And then even victims. Usually, you know, if you shoot two people, two victims, that's going to be two separate charges. However, there was that case with cattle theft where it was the cattle belonged to two individual owners, but they were in the same field. So it was one impulse to steal the cattle from that field. So again, it's not definitive. It's going to be case by case. And here, he was charged with the aggravated assault for the dog, and he was charged with just or aggravated battery, excuse me, and then he was charged with the battery for the shove. The testimony proved that both occurred.
See, my concern is that we sit here and analyze the facts of this case in slow motion.
Right.
I mean, this is happening like this. You know, and that, in my mind, determines what is one episode or not. I mean, if it's happening quickly, he shoves the officer shoves back, suddenly, go get him, dog. It seems to be happening really quickly.
Right, and that is a factor to consider, but again, like I said in Drowdy, or this court said in Drowdy, the acts can be simultaneous, or, you know, in a case where we have two victims, if someone shoots both and it's two bang, bang, two trigger pulls immediately after each other, each trigger pull would be a different impulse in a separate and distinct act. Right. As opposed to...
Would that, the two shots, is that the same victim or two victims?
It could be, if it's two victims, it's easy, potentially. But then, as a counterexample, it would depend on the type of gun used and the setting used. So if it was a semi-automatic pistol and you have two trigger pulls, that's two separate acts. But say I have an assault rifle that's set to a burst mode, I pull the trigger, 3 or more bullets come out, that's one trigger pull, that's one act. Potentially, if they hit the same person, you would have one charge, and potentially even if they hit two people, depending on the rest of the facts, you potentially have one charge because there's only the one single trigger pull, and that's why it's not a bright line rule. Each case, you're going to have to go back and look at the specific factors.
Can I ask you to not think about the facts of this case or any other case for a minute and look at the elements of the two crimes that were charged and at issue in this case, aggravated battery and battery. And would you agree that battery is subsumed within aggravated battery? If you've committed an aggravated battery, you've necessarily committed a battery.
Yes, I would agree with that. And if we were to get to the third step, the Blockburger, because we have a single act, then you would run into a double. So, for example, if I were to if a defendant were to punch...
And another way to say that is that the aggravated battery statute doesn't require proof of an element that the battery statute does. Right.
Right. Okay. And if you're a single act, so a defendant punches a 70-year-old, they're going to be they're not simultaneously going to be convicted of a battery of someone over 65 and just a battery.
Okay. So thinking still generally about the law and what the statute lays out as the offenses. And we have here, and I'm going back to 775-0214A, whoever in the course of one criminal transaction or episode, you've conceded that there's one larger criminal transaction or episode, that's the one that was charged as the aggravated battery. The defendant commits an act or acts which constitute one or more separate criminal episodes. We have that. Right. Separate criminal offenses. Right. So he did commit a battery, and during the course of the battery, then the legislature says that they should be punished separately if they are separate offenses. And then it says, for purposes of this subsection, offenses are separate if each offense requires proof of an element that the other does not, without regard to the accusatory pleading or the proof adduced at trial. So in this case, because aggravated battery is separate under that definition, it's completely subsumed, why isn't this statute, subsection A, telling us that because it was one criminal transaction or episode, both acts are not treated as separate because they're not separate under the definition?
Well, I believe in this case, the different element of proof would be the dog attack versus the shove. Those are different.
But the statute's talking about without regard to the accusatory pleading or proof adduced at trial. We're talking about when we're deciding whether something is separate under subsection A, it's very clear the legislature says only look at the statute and the elements of the offenses and whether one is completely subsumed within the other. I mean, that's what the statute says.
Right, and that would be for one single act, but under
no,
that...
what it says, it's for any act that's committed during one criminal transaction or episode.
Yes, for any single act should be, but separate acts should be punished separately. Otherwise,
but then it gives you the definition of separate, and that definition says don't look at the facts at trial at all. Look only at the statutes, and if one is subsumed within the other, then it's not separate. I mean, I don't know how you can read subsection A.
Well, then that would invalidate Blockberger itself, because there they said this is one criminal episode, and it was a series of similar charges of drug transactions over several days. And
well, but then you look at whether it's one transaction or episode. If there's a temporal break, that kind of thing, I mean, that would be...
Well, and going to Blockberger, they said these series of drug transactions are one episode.
But if it's an issue of legislative intent, under the Double Jeopardy Clause, and the Florida legislature has answered the question in this case in 7750214A, why would we look anywhere else?
Because, again, Your Honor, by that the interpretation you're potentially saying skips the second part of the analysis. It would
the second part of the analysis according to the statute? Where is that in the statute?
Well, the statute said is the intent of the legislator for each criminal offense to be punished separately during each episode. I don't believe it's the legislator's intent to create a situation that as long as I commit the same offense over and over and over again, I only get punished once for it.
I think this is an interesting question of interpretation of this statute. I think what Justice Lawson is suggesting is that essentially that provision should be read as saying offenses are separate only if each offense requires proof of an element that the other does not. And I think the question is whether that's the proper way to read it when you look at it in context of what goes before and this expression of the legislative intent to punish for every separate offense. Right. And whether this is a specification that's exclusive, or this is just specifying a circumstance in which offenses are separate.
Right, and I agree with that. And I think this court provides an example in Droughty when it talks about how the molestation, groping the victim's breast, was a separate and distinct act from the penetration, and then gives a counterexample saying that, like, in the course of the penetration, if the defendant had groped the victim's buttocks to assist in the penetration, that's not a separate and distinct act because it's an act in furtherance of the penetration versus whereas the groping, you don't have to do one to do the other.
I'm sorry to interrupt you. Can I ask you a question? So if we take the battery statute as it's written and we take the Blockberger implementing statute as it's written, is it permissible if you have a situation where there's a fight, there's only one victim, and there are 10 punches thrown? Could the state charge 10 different crimes? And, if there's proof that, if the jury believes that 10 blows.
Potentially you could, if you could prove that each one was a different impulse. And I think a good example of that would be.
I'm sorry, okay. And so where does the impulse, are you getting that from the case law, or where, I'm trying to understand if that's a textual thing or where, because I'm trying to understand what makes this case different from a single fight where 2 punches are landed?
I believe the impulse language, and I don't have the exact quote, comes from Blockberger itself, and
that is definitely in Blockberger.
So
yeah,
it's
and I was going to
gloss.
say it's rather archaic, so it's a little harder to memorize.
So it's basically, and I'm not saying that that's wrong, but basically it's, you have to sort of read Blockberger, read the statutes. There's nothing, you would point to textually that kind of leads you down that path.
Outside of the intent is to punish each criminal offense within each episode. Going back a little easier, if I hold up a defendant robs a bank and there's 10 victims and he goes to each person and robs them individually, that's 10 individual robberies.
Why wouldn't you answer that question in terms of the? Go ahead.
But counsel, for the state to prevail in this case, the court would not have to adopt a per touch theory. I mean, this is a different kind of circumstance.
Right, and like I said, there's no bright
Could you
line rule.
just be, because you're almost out of time, be as clear as possible, though, as to what is the principal distinction? I think everybody's worried about a per touch thing, or everyone would want to know that that's the, if that was the implication of whatever gets decided here. But what is it about? Can you be as clear as possible and say what is the rule that we would articulate that would separate this case from a, 1 fight, 2 punches equals 2 crimes?
Well, and I don't know if you could necessarily completely separate them, because there would be potential circumstances where multiple punches would be 2 offenses, similar to the first district's opinion in Mercer, where you had a punch and then where it was a punch and then a kick.
But those were administered by 2 different people.
Right.
I mean,
here,
one is as a principal and one as,
and here you could argue he is a principal to the dog attack by ordering the dog to attack, and he physically pushed the officer himself. I mean, it's not a perfect analysis, but it's similar.
So the dog is, it's like.
But I think here you would have to, the court should articulate that it's a 3-part test. First, is it the same criminal episode or not? If it's different criminal episodes, you don't move on. Second, is it a distinct criminal act? Is it a separate impulse of a distinct character? If it is a distinct criminal act, you don't move on.
Why are you even conceding that it's the same criminal episode?
Yeah, I was going to ask that too.
Because I think you have the same victim, and we're talking about a minute of time. It's an action by the officer, a reaction by the appellant.
Well, you're conceding that partly because it was conceded in the district court, I would assume. That's been conceded throughout, right?
And I think here, I mean, I think it would be hard to articulate that this would be 2 distinct episodes, and I think that's the confusion that some courts have caused before.
Wouldn't it be more simpler just to apply the plain language of the statute? Because we're talking, whoever in the course of a criminal transaction or episode, we know here we have the larger criminal transaction or episode, a person commits an act or acts that constitute separate criminal offenses. We know we have that scenario here.
Right.
And so if the statute gives the answer in the framework in which the statute talks about the legal issue, why would we add an additional? Why would we talk about whether one of the acts that we're talking about is a distinct act? What does this judicially created look at something else make sense given the plain language of the statute?
Well, I think what we're saying is distinct act is mirroring the statute. And that
a distinct act would be an act, right? Whether it's distinct or not. So if it happens during the course of a different criminal transaction, in this case the aggravated battery, it can be a distinct act, but it's still an act, and the statute tells you what to do with an act, depending on whether it's separate or not.
Yes, and I believe that's what the state is arguing here. If it's separate acts, and again, this is a distinction between, like the Riviera case, where potentially you had someone stabbing and punching in the same act. It was like,
but again, I know you're out of time, but for purposes of this subsection, offenses are separate if each offense requires proof of an element that the other does not, without regard to the facts of the case or the accusatory pleading. Under that definition, are they separate?
Yes, because otherwise you would end up in the situation
Well,
where...
wait. No, I mean, you conceded earlier that one was consumed, the elements of one were consumed within the other when you look only at the statutes. Don't consider, as statute directs, the proof at trial, what happened, what didn't happen.
Right, but under that, if you were to take that to the extreme, Your Honor, you would have a case like Blockberger where you had the same charge, where they're the exact same elements, but they were able to stood because they were different acts.
Was the United States Supreme Court applying 7750214 in Blockberger?
No, but 77204 was adopted in Blockberger as a standard. And again, you would end up in this situation where I could never charge you with the same offense, even if they are distinct acts, because they're the exact same elements. So if
no, if they're separate criminal transactions or episodes, you could, correct?
Well, I think there's.
So, for example, you have the simplest of batteries, do not touch me, and the person touches you 3 times. One transaction or 2?
I think one transaction with 3 acts.
You have another circumstance where the person says, do not touch me. There, I touched you. I dare you to do that again. Do not touch me. 2 or 1 criminal episodes?
The state's position there is potentially you have 1 episode with 2 distinct acts.
Even with the temporal break and the different intent? The formulation of a new intent to touch a second time?
Well, I think that's what makes it a new act, is a new intent, or not necessarily a new intent, but a new impulse. Okay. Because again, in Blockberger, a series of drug transactions, arguably, that's all the same intent to sell the drugs, but each transaction was a new impulse. And for the reasons argued now and in our brief, the state asks this court to uphold the First District's decision. Thank you.
The state's concession to a single criminal episode does allow this court to resolve the issue here with the statute. Justice Kennedy, I told you I'd get back to you on the citation on Lee. Lee is cited in the respondent's answer brief. You are correct that it is not on the table of cases cited in the petitioner's initial brief.
So you didn't really argue this issue about the way that it was charged in your initial brief?
The state...
You made an argument here where you started off relying on the way the state charged the case. And you said that you should prevail on that. And what I asked you, you mentioned a case, but what I specifically asked you also was where you argued that in your initial brief. And if you didn't argue it in the initial brief, just say you didn't. If you did, point me to where it was.
I don't see in the initial brief where the argument was made. The initial brief discusses the distinct acts issue, which is
okay. So you didn't make that argument. The argument you started off with, the oral argument, was an argument that was not made in the initial brief.
The argument of moving past the charging document and into the distinct acts, I think, is what the initial brief centers on. And it talks a lot about the initial brief. The initial brief talks a lot about how it's a single criminal episode and how these are not distinct acts.
Well, I know that. And I know that.
Yes,
I read the brief. But what mystified me when I heard your argument, I said, did I miss that in the brief? And now I found out I didn't miss it in the brief. You're just arguing something that wasn't in the brief, correct?
And there was a lot of talk about the testimony in the brief.
I understand.
And how it comes back to, the testimony at the trial cannot cure what is a charging defect in the record.
Counsel, I just, if you didn't argue it, you didn't argue it. But we can move on.
Counsel, you can have 30 seconds to sum up.
Thank you, Chief Justice. The exception to the legislative intent to convict and sentence for each offense doesn't apply where the offenses are the lesser offenses and the statutory elements of which are subsumed by the greater offense. That is what we have here, and it does conflict with what the 4th District did in Olivard. That's why this court has jurisdiction, and that's why this court should grant the relief that I requested at the beginning of my oral argument. Thank you.
Thank you.
All right.